Court of the 1st Judicial District of Hinds County, Mississippi is now in session. The Honorable Deborah K. Halford, Special Judge, presiding. Please remain standing. In accordance with Judge Halford's standard practice, those of you who wish, you're invited to join us for a moment of prayer and reflection brought by Reverend Calvin Cosnahan, serving as a special chaplain for today's session. All others are requested to remain silent and respectful of the court decorum during this time.
Lord, we pray for the presence of your Holy Spirit in this courtroom today. We lay before you our passions, emotions, and anxieties concerning the issues involved in this case. We seek your truth, not our own. We seek your wisdom, not our own. Bless and inspire Judge Halford in her deliberations and judgments here today. Bless and inspire all those who address this honorable court to do so with a sense of your presence and your will for them today. Enlighten our minds, strengthen our spirit, and fill our hearts with love, wisdom, and understanding. Lastly, Lord, we pray that you grant that the cause of truth, justice, and humanity shall in no wise suffer in the proceedings today. We thank you, Lord, in advance for all that you're going to do in our midst. Amen.
Be seated. No entry or exit from the courtroom will be allowed while court is in session and Judge Halford is on the bench.
Thank you. Court now calls the case Jackson Women's Health Organization and others versus Thomas E. Dobbs, MD, and others. Calls number 25-22-739. What says the plaintiff?
Plaintiff is ready to proceed, Your Honor.
And what says the defense?
Thank you, Your Honor. The defendants are prepared to proceed as well.
All right. As a matter of procedure at this point in time, even though the court is cognizant that COVID is still a very real issue, and that it continues to present problems and that there is actually a current surge, the court finds it helpful that persons who are addressing the court would lower their mask so that the court has no difficulty in understanding that which you're saying. Okay, thank you. All right. Is there anything preliminary to be addressed before we start?
Nothing from the plaintiff.
No, for the defendants, Your Honor.
All right, so I'm a nominal defendant. I'd like to be released. The court sees fit. Good to see you and welcome to Hinds County.
Thank you. All right, we will. Let's, for the record, let's note counsel for the parties that are here, and then the ones that are appearing in their own behalf. We would start with the plaintiff's side and identify all counsel who will be appearing here today.
Good morning, Your Honor. Rob McDuff of the Mississippi Center for Justice for the plaintiff, Jackson Women's Health Organization et al., and I'm joined by my co-counsel Hillary Schneller of the Center for Reproductive Rights.
Thank you.
Thank you, Your Honor. Scott Stewart on behalf of the state defendants. I'm here with Attorney General Lynn Fitch, my colleague Justin Matheny, Doug Miracle, and Wilson Minor have also entered appearances in this case. Thank you, Your Honor.
Good morning, Your Honor. Claire Barker on behalf of the City of Jackson and Katoria Martin as the City Attorney for the City of Jackson.
Thank you.
Gerald Mumford is the county attorney in my official capacity.
Other than Mr. Mumford, is there anyone else that wishes to be released from the proceedings here today?
Your Honor, the City of Jackson requests that we be released from these proceedings as it is only the City Attorney in her official capacity.
Those requests will be granted. Mr. Mumford and Ms. Barber will be allowed to exit from the proceedings if they so desire. Anything else for the good of the order before we begin? All right, Mr. McDuff, it's your show.
Thank you. you, Your Honor, and good morning. We are here this morning seeking to uphold a decision of the Mississippi Supreme Court in 1998 holding that the Mississippi Constitution protects the right to an abortion, the right of an individual not to be forced by the state to carry a pregnancy to term and to give birth against her will, but instead to make her own decision about one of the most important things that can happen to a person, one of the most important things that can happen to a family. And we are here to ask this court, which is required to follow the decisions of the Mississippi Supreme Court, to issue a preliminary order preventing the enforcement of two laws, the trigger ban and the 6-week ban, both of which would violate that right. Now, while there is great disagreement in this state about abortion and about the related question of when life begins, those questions are not before you. The primary issue before the court is whether that decision of the Mississippi Supreme Court is binding. And we believe it clearly is. Just as the federal government has the United States Constitution, interpreted and applied by the federal courts with the ultimate decisions to be made by the United States Supreme Court, each of the 50 states has their own constitution, each of which is interpreted by the Supreme Courts of those states, and some of which are interpreted at times to grant more rights to individuals than the federal Constitution does. In 1998, the Mississippi Supreme Court decided pro-choice versus Fordyce, holding, as I said, that an individual has the right to an abortion. The individual has a right to make those decisions herself, rather than having them made for her by the state. On Friday, 11 days ago, the United States Supreme Court issued its decision in Dobbs versus Jackson Women's Health Organization, overruling Roe versus Wade, discarding 50 years of precedent, and holding that the federal Constitution no longer protects the right to an abortion. On the following Monday, we filed this lawsuit invoking the right to an abortion under the Mississippi Constitution, and that's what we seek to enforce here today. Now, the Dobbs opinion by the U.S. Supreme Court only addresses federal law. It does not address Mississippi constitutional law, and of course it does not purport to overrule the precedent in the Fordyce case. That's because it can't. The Supreme Court cannot do that, and of course neither can this court. The prerogative of overruling any decision of the Mississippi Supreme Court belongs only to that court, and that's why we believe the decision before you today, although it might be related to very complicated issues, is really quite simple. Now, the defendants, of course, have urged you to cast aside the 1998 decision and hold that it is no longer valid because Roe versus Wade has been overruled. And they claim that the Fordyce, the opinion of the Mississippi Supreme Court, called the decision in Roe versus Wade very important to the question of whether the state constitution protects the right to an abortion. But in actuality, the opinion in Fordyce said the following: in asserting that the Mississippi Constitution does not protect the right to abortion under the Privacy Clause, etc., the state, talking about the state in its argument back then in 1998, the state fails to take into account some very important considerations. That's what they're quoting from. What are those important considerations? Right after that sentence, the Mississippi Supreme Court referred to Roe, but only to the extent Roe discussed the legality of abortion from Greek times to the present day. That was simply a prelude to the Mississippi Supreme Court's discussion of the history of abortion law in Mississippi. And the Supreme Court, in that discussion, pointed out that at the time the Mississippi Constitution was adopted, in 1890, abortion was legal until quickening some 4 to 5 months into pregnancy. The other, quote, very important consideration that the Mississippi Supreme Court mentioned in that opinion was the right to privacy, which had been venerated and expounded in many prior precedents of the Mississippi Supreme Court, and which the court in Fordyce called the most comprehensive and guarded right emanating from the Mississippi Constitution. From the Mississippi Constitution. So while the court said that Mississippi legal history and Mississippi case law regarding the Mississippi Constitution and the Mississippi right to privacy were, quote, very important considerations, end quote, in its decision, it never said that Roe was. Now, it is true, as the defendants have pointed out, that there are a number of references to Roe in the opinion. And there's an occasion where they say both the state and federal constitutions provide a right to privacy and a right to abortion. At one point, the opinion says, just as the federal constitution protects abortion as part of the right to privacy, so does the state constitution. But those are just descriptions of obvious facts. That yes, we are now holding the state constitution protects it, which means that both of them protect it. But it never said that their decision on the Mississippi Constitution rests on the federal Constitution. They never said it was dependent upon the federal Constitution. They never said it was made because of the federal Constitution. They never said it would evaporate if Roe was ever overruled. Instead, and this is near the end of the majority opinion, we were discussing the issue of res judicata. But here's what the Mississippi Supreme Court said. A federal court may not interpret the state constitution. We reserve the sole and absolute right to interpret the Mississippi Constitution. While the federal courts are free to determine the constitutionality of abortion statutes based on a federal analysis, the state reserves the right to determine state constitutionality. That's obviously what the court was doing in pro-choice versus Fordyce. And in fact, in another case, the Pennant case, the Mississippi Supreme Court anticipated what is happening right now. And they said, the words of our Mississippi Constitution are not balloons to be blown up or deflated every time and precisely in accord with the interpretation the U.S. Supreme Court adopts. And that's exactly what they're asking you to do. They are asking you, because the Dobbs decision deflated the right of abortion in the federal Constitution, for you to deflate and interpret precisely in accord with the U.S. Supreme Court's interpretation the right in the Mississippi Constitution. But clearly, that's not appropriate. Clearly, this is another balloon that is not to be blown up or deflated every time the interpretation of the United States Supreme Court changes. And most importantly, as I said earlier, this court cannot overrule Fordyce. Absent a clear directive from the Mississippi Supreme Court that it is overruled, and we do not have that, you are required to enforce it. Now, one thing that's interesting that we sometimes forget, I mentioned this in our brief, in our reply brief. In 2011, the voters of Mississippi had an opportunity to overrule that decision and to hold that the so-called personhood amendment, to hold that life begins at conception, completely banning abortion, and put that in the Mississippi Constitution. That amendment was rejected 58 to 42%. So the decision, the only way that decision in pro-choice versus Fordyce can be overruled is by the Mississippi Supreme Court or by the voters amending the Constitution. The voters refused to do that. And you obviously are not in a position to do that at this point. Now, the purpose of the preliminary injunction that we are seeking, or a temporary restraining order, whichever you choose to impose, is to preserve the status quo. To keep things as they are, preserve the rights in existence while the case while the merits of the case are litigated and resolved. The status quo in Mississippi for nearly 50 years, as a result of Roe versus Wade, and then later pro-choice versus Fordyce, has been that the decision of whether to carry through with the pregnancy, decision of where to give birth, belongs to the individual, not a majority of the legislature. And another thing that a lot of people don't know about, prior to that time, for the 156 years of statehood prior to 1973, in 135 of them, abortion prior to quickening, which was said to be 4 or 5 months, was legal. Abortion was legal in Mississippi for 135 of the 150 years, 6 years of statehood prior to Roe versus Wade, and it has been legal as a result of Roe and pro-choice versus Fordyce since that time. And Fordyce specifically noted that at the time the Mississippi Constitution was adopted, abortion was legal until quickening, some 4 to 5 months in pregnancy. So the status quo that we see and that we ask you to maintain is the status quo that has existed in the state of Mississippi, except for a very small period of time. And that status quo is required to prevent the irreparable harm that would come from the enforcement of an unconstitutional law. The irreparable harm that would befall our client, Jackson Women's Health Organization, which would be required to close its clinic, to keep it closed. Because otherwise, its doctors, including one of the plaintiffs, its nurses, its staff, could be subjected to 10 years in prison for just doing their job. Its doctors, its nurses could have their professional licenses taken away. But more importantly, the patients of the clinic, the women of Mississippi who do seek an abortion, who do make the decision that under the law only they can make, not the state, about whether they should carry a pregnancy to term and give birth, they will be forced to do those things against their will, many of them. So that is irreparable harm. And the status quo should be enforced by the court given the binding precedent of pro-choice versus Fordyce that protects those rights of the individuals, of the women of Mississippi. And so we simply ask that the court enforce that precedent, issue an order to preserve the status quo so that for the moment, while we litigate this case, we remain in the same legal posture that Mississippi has been in, more or less, for nearly all of its existence.
Thank you. Thank you, sir. Mr. Stewart?
Thank you, Your Honor. Again, for the record, may it please the court, I'm Scott Stewart on behalf of the state defendants. Your Honor, I want to try to cover, I think, 3 key areas that I think inform one another, but just provide a good way of thinking through this case and where we are today and compared to where we might have been a couple weeks ago. So I want to start with just some framing observations. I'll move then to the merits, and then I'll close with the equities, and perhaps also, if I may, try to respond to Mr. McDuff's points, unless Your Honor would prefer that I wait for another period to do that. First, just framing, Your Honor. In the past 2 weeks, the state of the law has changed dramatically, and the court needs to decide this motion based on the law as it now stands. You know, if this suit were filed a month ago, if this hearing were 2 weeks ago, things would be very different. The plaintiffs would have a much different claim. But, you know, and that's because 2 weeks ago, there was a Roe versus Wade, there was a Planned Parenthood versus Casey, and there was a pro-choice Mississippi versus Fordyce. That's no longer true. As a result of the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization, there is no Roe versus Wade, there is no Planned Parenthood versus Casey, and as a result, there is no pro-choice Mississippi versus Fordyce. I'm going to explain in a moment why the Dobbs decision, although it is a federal U.S. Supreme Court decision, dooms and defeats the plaintiff's merits position here, and then I will also talk about the equities and how it has a similar effect on there, even though we're here talking about our Constitution and state law, Your Honor. So beginning with the merits, Your Honor. Plaintiff's case, and I think nothing's changed since their papers, and Mr. McDuff reaffirms it today. Plaintiff's case rests entirely on the proposition that Fordyce protects a right to abortion and that it remains good law. That is wrong. The law as it now stands requires this court, and the law as it now stands under Fordyce itself requires this court to deny injunctive relief. Fordyce, it found a right to abortion. It said it did so under the state constitution, and the critical question, of course, is that still good law? And I think a good way to assess whether it's good law, Your Honor, is to think of different ways our state Supreme Court can and has and may go about evaluating our state constitution and the extent to which our state constitution protects certain rights. So I'd like to talk about just three different ways, and I think it's informative here. The first way, our state Supreme Court, it can construe our Constitution just independently of what the U.S. Supreme Court has done and says, hey, this is what our Constitution says, this is what it means, this is our history, this is what the enactors or adopters protected at the time. Mr. McDuff mentioned the Pennant case. The Pennant case may be a good example of that. It independently adopts a certain view of our state's analog to the Fourth Amendment. It then separately reaches a different conclusion and a different analysis under the federal Fourth Amendment. A second way, Your Honor, after the independent evaluation is that our state Supreme Court, it can look to guidance for the U.S. Supreme Court, but it can look to guidance and say, what does the U.S. Constitution protect according to the U.S. Supreme Court? But it uses that just as sort of a starting point, and it says, hey, we are a state court, we have a state constitution, and we can go farther in protecting certain rights. So it can provide more protection than a federal analog. The Downey case, we cite that one, that's an example of that. You know, the federal Fifth Amendment protecting Miranda right, our state Supreme Court says in Downey, we also protect that right, but we also hold that that right is a little bit broader and attaches a little bit more readily than the U.S. Supreme Court has held. So again, that's a second way to do that. And the critical thing here, the critical thing for Fordyce, is that when a state Supreme Court does either of those things, then a U.S. Supreme Court decision on the federal Constitution, it's likely not to affect those. It says what it says, but in different ways, a state Supreme Court has decided to do an independent, different thing under its own Constitution. It's independently construed it, or it's gone farther. So the U.S. Supreme Court decision is very unlikely, or far more unlikely, to affect anything. Critically here, though, Fordyce did not do either of those things. It did something else entirely, and what it did makes the difference here, and not only casts aside the heart of the plaintiff's case, but actually requires denying relief to plaintiffs in this case. So Fordyce took a third path. It adopted U.S. Supreme Court case law and projected that case law onto our state constitution. And the reasoning, and I think the critical reasoning in Fordyce, Your Honor, is at page 653 of the opinion, 716, sounds like at 653, and it's paragraphs 27 to 30. And there are other parts of the opinion that bear this out too. But that's really the critical analysis. And basically, the way the court reasoned in Fordyce was it says, the Mississippi Constitution doesn't expressly protect the right to abortion. Okay? But hey, the federal Constitution doesn't either expressly protect such a right, and the U.S. Supreme Court held in Roe v. Wade that the federal Constitution does protect a right of privacy, and that right of privacy includes and protects a right to abortion. From there, Fordyce reasoned that, okay, the Mississippi Constitution, our Mississippi Constitution, it also protects the right of privacy. In fact, it protects the same right of privacy. It cited In re Brown for that proposition, that, because we, and reasoned that because we, in our Constitution, protect the same right as the federal Constitution, if the federal Constitution protects the right to abortion, so too does our state Constitution. That's the conclusion the court reached, again, at the beginning of paragraph 30 on page 653 of Fordyce, Your Honor. The Mississippi Supreme Court went on to adopt Casey, its undue burden standard, and it repeatedly applied Casey, it applied Roe, it applied cases following Roe and Casey. We've included citations to those pages in our papers, Your Honor. And all that is really to say that Fordyce took a different approach. This was not an independent interpretation of our state Constitution. It was not a decision to go beyond what the U.S. Supreme Court had done. Actually, at page 658 to 660 of Fordyce itself, the Mississippi Supreme Court declined to do that. It said, hey, look, some other states have done that. We don't do that. It stuck with its reasoning that the two provisions were congruent, and therefore, because the federal one protected a right to abortion, the state one did as well. So, as I said before, Your Honor, That approach makes all the difference in this case. We have a different position as we'd be in a different position as the state if the Mississippi Supreme Court in Fordyce had taken path 1 or path 2. But it took path 3. And path 3 was completely dependent, thoroughly dependent on Roe and Casey. As everyone now agrees, there's no Roe and Casey anymore. And as a result, there is no Fordyce. There is no Fordyce to protect the right to abortion because the federal right of privacy, it no longer protects the right to abortion. By the reasoning that Fordyce requires the right of privacy under our state constitution, does not protect the right to abortion either. Fordyce, to the extent it teaches us anything, it is that this is the approach that our state Supreme Court is using in this context of projecting federal case law onto our Constitution in the abortion context. That approach requires the court, in this case, to use the same approach, at most, to use just rational basis review. Here, there's no dispute that under rational basis review, under the lenient standard of just seeing, hey, do these laws at issue substantially advance legitimate state interest, there's no doubt that these laws stand. So, Your Honor, I think that's the clear path of reasoning here. I would emphasize that Fordyce itself, again, it relied heavily on Roe and Casey and really projected the federal constitution onto them. My friend Mr. McDuff said you don't have a clear directive from the Mississippi Supreme Court. You do have a clear directive, Your Honor. You have the approach taken in Fordyce combined with the Mississippi Supreme Court's own case law. We cite, for example, the 1931 decision in Columbia Mutual Life Insurance Company. And what the court recognizes there, we've quoted the language, but the short proposition is that our state Supreme Court applies a rule that when one case rests on an earlier case's holding and the earlier case is overruled, the later case is necessarily overruled too. That's what you have here. Fordyce rested on the holding in Roe, on the holding in Casey. Those holdings have been unequivocally rejected and overruled. So necessarily, Roe and Casey, or necessarily, Fordyce's recognition of a right to abortion is no longer good law either. You don't need our state Supreme Court to tell you that, Your Honor. It's already signaled that in Columbia Mutual Life Insurance itself. Again, there's no dispute, Your Honor. I think this kind of simplifies things that, without a right to abortion, these laws stand. So with that, I just tie up the merits, and I'd mention a couple things on equities that I'd like to explain. So plaintiffs, of course, have the burden, because injunctive relief, as Your Honor, of course, is very familiar with, it is an extraordinary thing. They have to show not just merit success or likely merit success, but also that the equities favor them. And again, Dobbs has changed a lot of things here, but also just plaintiffs' own papers show that they have not made the equitable case needed for this court to halt a duly enacted law of the people that serves very, very powerful, important interests. So just whatever Your Honor thinks about the merits, the equities provides Your Honor with an independent reason to deny relief in this case. First, irreparable harm. So I think the plaintiffs themselves, they are abortion providers. The harms they claim are overwhelmingly derivative of those of their patients, so I will emphasize their patients. I would say that harms to the plaintiffs, they do not outweigh the harms on the other side, which I'll get to in a moment. As to plaintiffs' patients, though, Your Honor, plaintiffs' own submissions, their own affidavit emphasizes, hey, in this context, most of our patients, they seek abortion. They're women who are parents who don't want to have another child because they can't parent one at this time. It then follows that up in the affidavit by saying that some are women who are not, do not want to have children and instead want to pursue education and job opportunities. Plaintiffs point to various burdens that come with pregnancy and child rearing. We acknowledge those are important issues. Those are difficult burdens. But the two or three things that I would say is that they aren't irreparable in this context, especially when considered with the weighty interests on the other side. And also, they're heavily mitigated in a variety of ways, Your Honor. Our state has a range of laws, adoption laws, safe haven laws. There are tax credits, alternative options for, there are, of course, alternative options for work and education that allow some of those points to be mitigated. Different resources, pregnancy resource centers. There are a lot of things that mitigate those harms, and we don't diminish those. We understand the hard issues on both sides here, but those are heavily mitigated. The exceptions in the laws here, the life exceptions in particular, also mitigate those. Plaintiffs have not shown otherwise. They haven't come forth with plaintiffs that show an immediate sort of irreparable harm. So I think plaintiffs' own submissions show that they have not made a case of irreparable harm sufficient to, again, halt this duly enacted pair of laws in its tracks. As for the balance of equities in the public interest, Your Honor, this is the area where I think really hits home where things stand on the equitable considerations. The injunction here, the injunction of the laws here would damage crucial interests that these laws serve. I mean, as the Supreme Court explained in Dobbs, legislatures adopt laws like these to protect unborn life, to protect women's health, to protect the medical profession from participating in these very potentially gruesome and just very searing procedures, many other interests, and just halting them would halt in its tracks all of those interests that could potentially be served, if these laws go into effect. Anytime a state law is enjoined, Your Honor, I'd add that the state is irreparably harmed. But I hear it's even starker than other areas, Your Honor. I mean, as the Supreme Court in Dobbs, emphasized for us, and I think this is, very, very intuitive and applies as we're thinking about things here, is that this is an area, abortion presents a very hard area with interests on different sides, but it's one unusually and uniquely entrusted to the judgment of policymakers, the people's elected representatives. So when it comes to deciding policy arguments and weighing those arguments, those are really for the people. And the people's representatives have, in the laws here, decided which ones that they think are critical, that they think prevail. My friends do make a number of policy arguments, but in this context, those are arguments that are for the people to weigh and decide. I mean, I think, just thinking about, what legislators may be thinking of, may have thought of when they, passed these laws or laws like them. Under these laws, in a year, hundreds of new young Mississippians, weeks or months old, they'll be living, breathing, playing, laughing, moving to solid foods in months, all those sorts of things. Legislatures could reasonably see, hey, those are incredibly, profoundly important interests. We want to pursue those. We want to protect others. We acknowledge and appreciate the hard interests and hard issues on the other side, but in the end, we are the elected representatives. The people enacted us to make these hard decisions, and we draw the balance this way. That's what the court's done in this law, and after Dobbs, that view was the one that has to prevail on the equities in this case, Your Honor. So I'd say the equities favor the state defendants. They require denying any injunctive relief, and they mean that the laws here that are enacted by the people's elected representatives should take effect. I just sum up by saying, Your Honor, for these reasons, the court should deny any injunctive relief. If the court were to grant any injunctive relief, the state would respectfully ask the court to stay that relief pending appeal. But again, we don't think the court needs to even get there. And for the reasons I've given on the merits, we ask the court also to enter final judgment because the plaintiffs just do not have a case on the merits left, with Fordyce having fallen after Roe and Casey fell. And with that, Your Honor, I think I would close by just noting one last point for Mr. McDuff. He mentioned the status quo. The status quo, he emphasized this in particular on the reply and asked that the injunction, kind of preserve the status quo. The status quo was not the one he referred to. The status quo is what exists after the Supreme Court's decision in Dobbs. And the Mississippi legislature told us long ago what that status quo was. It was that our law, Mississippi Code Annotated Section 41, 41, 45, would take effect 10 days following an Attorney General determination. That is the law we have. The status quo is that that law will take effect on Thursday and reflect the duly enacted will of the people. We respectfully suggest that and submit that injunctive relief to upset that status quo would be improper for that further reason. With that, we ask the court to deny relief and dismiss the case. Thank you, Your Honor.
Mr. McDuff, would you care to be heard further?
I would.
Thank you.
Solicitor General said that these are decisions that are for the people and their elected representatives. But the whole point of the Bill of Rights is that there are some rights and some decisions that belong to the individuals that are not subject to a vote, that are not subject to what the majority of the state legislature says. And, if the issue of assignment to public schools on the basis of race and school segregation had been put to a vote in 1954 by the people, we might still be, and certainly would have been for a long time, attending segregated schools based on race. The issue of interracial marriage in 1967 had been put up to a vote of the people. we might still be, and for certainly a long time would have been, unable to marry someone outside of our own race. And the Mississippi Supreme Court in pro-choice versus Fordyce has said that this decision, the decision about whether to carry a pregnancy to term and give birth to a child, one of the most important decisions a person can make, belongs to the individual, not to a majority of the state legislature. Now, during his discussion of the Fordyce opinion, the Solicitor General talked about how states make independent determinations on their own constitution. And among other things, he said, they say this is our history. Well, that's precisely what the Supreme Court did in pro-choice versus Fordyce. It said this is our history. And this is our right to privacy. And this is how we have interpreted it over the years. And this is one of the most fundamental and strongest rights emanating from our Constitution. It very much was grounded in Mississippi history and Mississippi law and the Mississippi Constitution. And he was unable, he described the opinion, and he said it relied heavily on Roe versus Casey. It projected federal case law under the Mississippi Constitution. But he didn't give you a single quote. Not a single quote where the Mississippi Supreme Court said, this rests on Roe versus Wade. We are basing our decision on Roe versus Wade. We are following Roe versus Wade in lockstep. We are dependent upon Roe versus Wade. Instead, they relied on Mississippi law and Mississippi history to reach a conclusion that is consistent with Roe versus Wade. But there's nothing wrong with that. That doesn't mean that it's dictated by federal law. And specifically, and this is where the Pinnock quote comes in again, where the Supreme Court said, Mississippi Supreme Court said in Pinnock, that the words of our Mississippi Constitution are not balloons to be blown up or deflated every time the U.S. Supreme Court changes its interpretation. In other words, if the Supreme Court blows up and adds to a right, we don't necessarily follow it. But this is what's important. When it deflates one, as it did 11 days ago, we don't follow that either. We do not follow precisely in accord with the interpretation of the U.S. Supreme Court. And that's really the end of it. That's really the end of the analysis. Now, he did refer to the Columbia Mutual case. We pointed out in our reply brief that that was a case where the Mississippi Supreme Court said, we previously overruled a case which has the effect of overruling another Mississippi Supreme Court case that followed that case. But those were all situations where the Mississippi Supreme Court had overruled one of its earlier decisions. This is totally different. The Mississippi Supreme Court has not overruled this decision, and the U.S. Supreme Court hasn't either. Finally, to the issue of irreparable harm. This is, first of all, the clinic and its doctors have rights that are not derivative. They could go to prison. They could lose their licenses. So they have their own independent harm. But beyond that, the notion that the harm that comes to an individual who wants to make her own decision and chooses not to carry through with a pregnancy and bear a child against her will, but somehow is required to, if these laws aren't enjoined, if it's not irreparable, you bear a child against your will, that is not irreparable? How do you put that back? It's absurd. And clearly it's irreparable. And the Solicitor General talked about, well, the things that the legislature has done to make life easier for women who are forced to bear children against their will. They didn't expand Medicaid. They didn't extend postpartum Medicaid benefits beyond the 2 months that exist now. So I think a lot of people would disagree with that. But here's the point. The decisions about whether to extend Medicaid, whether to extend postpartum Medicaid, as regrettable as those are to a lot of people in this state, those were decisions the legislature had the right to make. It involved tax money, it involved public funds, but the decision about whether to carry a pregnancy to term and bear a child against your will, the decision about whether to do that is not something that the state can force on you. You do not become the property of the state or the appendage of the state just because you become pregnant. And the Mississippi Supreme Court in pro-choice versus Fordyce, it says that's the law in Mississippi based on the Mississippi Constitution. And because you are required to follow the law, the temporary restraining order, the preliminary injunction should be issued. Thank you.
Okay, counsel, is there anything else on the argument that I need to hear? I told you in our phone conference that we would be lenient in giving everyone an opportunity to be heard. I certainly want to be adequately informed. You may...
Your Honor, if you don't mind, I'll just briefly mention perhaps 2 or 3 points. First, Mr. McDuff mentioned, you kind of invoked the point of a Bill of Rights is that you don't have things that can be changed or affected by legislative majority. That language is very familiar. It comes from, it was a point made by, in the Dobbs case, the problem is it was made by the dissent. That view was rejected in this context firmly by the majority of the Supreme Court. And again, Mr. McDuff is trying to rely on a path of reasoning that has now been unequivocally rejected. Number 2, Your Honor, on Mr. McDuff sort of says that Fordyce doesn't contain sort of a magic set of words saying that we, the Supreme Court, will do absolutely whatever. The Supreme Court of Mississippi will do whatever the U.S. Supreme Court tells us to on this issue. I'm aware of no magic words requirement. Columbia Mutual Life Insurance kind of defies that, Your Honor, and basically says, hey, look, this earlier case was overruled. This later case rested on that earlier case. So that case was necessarily overruled, too. It was not a lot of fanfare. It was not a lot of analysis. It just recognized kind of the obvious logical implication. The last point I'll just kind of close with, Your Honor, is to kind of finish where I pretty much started with, is that Mr. McDuff's argument sounds overwhelmingly like it would have 2 weeks ago, and that just cannot be right. We're in a very, very different world, whereas I emphasized, in a world without Roe and without Casey, Fordyce is not the same. Fordyce is gone, and what is all the signals that Fordyce gives calls for this court to deny relief and dismiss this case. Thank you, Your Honor.
All right, before we conclude here today, I want to address on the record the order setting this today clearly set it on whether or not the court would enter any preliminary injunctive relief. The state defendants have filed a motion to dismiss. The plaintiffs have requested instruction from the court previous today should they file any sort of written response to the motion to dismiss. I think the court administrator notified counsel for the plaintiffs that absent some agreement by the parties that the motion to dismiss would not be taken up today. The state defendants have urged the court to go ahead and address the motion to dismiss. At this point, given the order setting the matter and the communications between the court administrator and counsel for the plaintiffs, absent there being some agreement between the parties that you wanted the court to go ahead and rule on the motion, then that would not be taken up. Can I hear from you on that?
We do not have such an agreement.
Okay. And do you oppose then the court going ahead and entertaining the motion to dismiss?
We do oppose that. I was not, other than Mr. Stewart actually saying a minute ago something about entering final judgment, I was not aware that had even been requested, but yes.
I can't wait for you to object to it. Now I'm inviting you.
There's no jury here, so yes, we do object to that. We believe, as set forth in the court administrator's email this morning, that the motion to dismiss should be addressed at a later time, and we will respond in due course as the court instructs.
Now, counsel, In the earlier phone conference, you both indicated that this was strictly a legal issue, that there would be no witnesses presented. The court has received very helpful briefing from both sides, that whereas those briefs necessarily do brush on and touch the issue, the merits of the issues, they are designed and tailored toward the issue of whether preliminary injunctive relief is granted. If you're in a position to tell the court now, or if you're not, I'm going to give you a limited window of opportunity to do so. Do you want the court submitted on the merits, on the briefs that have already been submitted, or do you wish an opportunity to submit further briefing and argument down the road?
You're asking with respect to the motion to dismiss?
Yeah, and on the merits.
Yes, we would like an opportunity for further briefing on that.
And my apologies, Your Honor, if I don't mean to needlessly represent. Mr. McDuck, are you saying further briefing on the injunctive relief matter, or just further briefing
On the merits.
On the merits.
On the merits? We'd like to reply to any opposition or response that Mr. McDuck replies, but we don't think much more is needed on that, Your Honor.
All right. Anything else for the good of the order today?
There you are.
Council entertain a motion on the injunction today? For the bench? Do y'all want me to rule on the bench? No, sir. We'll take this under advisement. The court expects to be able to publish a decision simply and only on whether to issue the preliminary injunction, and it will be published to council and to the public through the Mississippi electronic court system notice of electronic filings. Thank you.
Thank you, Your Honor.
Your Honor.
All rise.